Our speaker for today is such with great and many achievements, and it is very tough for me or for anyone else to count on all the achievements in such a short time. So I'll like, for the benefit of all young entrepreneurs, young professionals, and all participants, in short, I'll try to read a few of the achievements so that all the young participants and professionals will get a feel about Dr. Singhvi's great and long career. Dr. Abhishek Singhvi is a senior three-term and sitting member of the Rajya Sabha and well known as India's foremost senior advocate and jurist. He is a former chairman, Parliamentary Standing Committee on Law and Justice. He was India's youngest designated senior advocate at 34 and India's youngest appointed additional Solicitor General at age 37 in 1997. He is a well-known author and columnist and a visible media personality. He is also the senior most serving national spokesperson of the Congress Party. His columns have appeared in India's top English dailies and have been published as two books, titled as Candid Corner and Straight Talk, both with forewords written by Dr. Manmohan Singh, our ex-Prime Minister. He is also an occasional columnist in major Hindi dailies, Dainik Bhaskar and Rajasthan Patrika, awarded the Global Leader for Tomorrow Award by World Economic Forum at Davos in 1999. Dr. Singhvi has been the opening lead speaker for the Treasury Congress benches in Parliament for almost every major debate from year 2006 to 2013. He has been the common factor in almost all landmark Supreme Court cases spanning constitutional law, corporate law and arbitration, and several other subjects. He supports many charities, including the Prayas Center for Destitute Children and the Singhvi Scholarship at Trinity College, Cambridge. This is apart from the sterling work done by him over 12 years in Rajasthan from his MPLAD funds, supporting 400 projects in the field of health and education. He is former chairman, Indo-US Forum of Parliamentarians.
Can I request you, Harsh? Thanks, you're very generous. I think that's enough. You've been very generous.
Sir, it is just two more points so that the audience must know. He has led many delegations to Yale University. He is also former president SARC Law, an apex NGO, judges, lawyers, and law person of the SARC region. He is a former member governing body National Law University of Jodhpur and Delhi. Dr. Singhvi topped India at the school level, Indian School Certificate exam, and did BA Economic Honours from St. Stephen's College and MA and PhD from Trinity College, Cambridge, UK. He also taught at St. John's College, Cambridge, and did a brief summer program from Harvard, USA. So I welcome you again, sir. And I'll take this opportunity to mention and to highlight this, that Dr. Singhvi had committed to FICCI to speak on these subjects for the first time at their platform. And we are very lucky, and because of Dr. Singhvi being generous, JITO and JP have got this opportunity where Dr. Singhvi would be speaking on these legal issues for the first time on JPF and JITO platform. We welcome you, sir. Now I'll invite you, sir, to share your views on our first topic regarding the frustration of contract, invoking of force majeure clause, act of God from a legal and juristic perspective in detail, sir. Sir, over to you, sir.
Namaskar and Jai Janendra. Thank you, Harsh, and all the organizers very much for a most generous introduction. While we are now combating COVID in difficult times, I'm sure we are also being careful about the other virus we are told about yesterday in a lighter vein, Zoom. The true definition of Kali Yuga is that you protect one virus, you are scared of another virus. But that is entirely in a lighter vein because we have now some 700 odd people, I'm told, on Zoom. Incidentally, I just heard this afternoon that the UK Parliament is meeting through Zoom. So obviously it's not a dangerous virus. Friends, there are always silver linings in dark clouds. And amidst the dark clouds of Corona, the silver lining is the huge amount of humor which Corona has spawned. I wrote an article recently on Corona jokes, and my two favorite ones are where a psychiatrist association issues a notice to all its members saying it is normal during Corona to talk to pets, to talk to plants and trees. and there is no need to worry and no need to contact us if you do that. You need to contact us only if you think that the plants and pets are replying. And the other one which took the cake was when a pharmacist was supposed to have fainted, when a lady asked him at the counter to give a mask matching the color of the sari. As I said, all dark clouds have silver linings. Friends, what are we talking about today? In the first part, roughly half an hour, I will talk about force majeure frustration, then a Q&A, and then a very short 10-15 minutes on wages, followed again by a Q&A. Now, it is important that I've been asked to talk on legal issues, on legal principles, on the law relating to this subject. It's equally important to note what I'm not talking about. I'm not talking about equity, about mercy, about good conduct, about decency. I'm not talking about situations where consensually and amicably you and me arrive at solutions, which should be the norm of the day. And I'm certainly not talking about that which ought to be, because ought to be means that we should all collaboratively and consensually solve problems in these difficult times. I am talking of what is the law. And it is therefore to some extent a technical talk. I will speak broadly on 4 or 5 issues. One, tell you the broad statutory and case law backdrop. 2, cull out 10, 12, 14 principles from those statutory and case law context. Principles relating to force majeure frustration. Then I will try and also tell you what happened in those actual cases, why the force majeure plea was denied by the courts on the factual aspects. So first the legal part, then the factual part. And then last but not the least, try and take up a few practical issues arising during COVID and tell you how and to what extent the law of force majeure applies. Well, friends, if you were to ask me, students of law or as people who want to imbibe knowledge, how to look into the subject, and of course I assume that most of you are non-lawyers, then the 2 things of the statutory law you must look at is section 32 of the Contract Act and section 56 of the Contract Act. Section 32, which occurs in a chapter called chapter 3, deals with contingent contracts. And it says that contracts to do or not to do anything if an uncertain future event happens. Such contracts cannot be enforced unless and until that event happens. And if it doesn't happen or that event becomes impossible, then the contract is void. That is one part of the Contract Act, statutory. The other part is section 56, a fairly detailed provision. It starts with presenti. So it says if you and I contract to do an impossible act, an act impossible in itself, the section uses the word in itself, then that contract is void. And it gives illustrations. A contract to predict the share price by astrology, it's a void contract. A contract to cure something by black magic or by magic, contract void, because it's a contract for impossibility. Then it goes further to say a contract this was present time when the contract is made, but in future, a contract also which subsequently becomes either impossible by supervening or subsequent events or unlawful by such supervening or subsequent events. Then again it becomes void, and the voidness attaches from the time where it becomes either impossible or unlawful. So this is the broad concept of the statute. It is obviously a codification of English common law. Just a small aside, a quick aside for you. The aside is this, that, the British certainly looted our country, took away a lot of our things, and many of them were in fact India haters and made very condescending and patronizing remarks about Indians. One of them was Macaulay, but the other, of course, as you know, was Churchill. But if you're objective, you'll have to grant it to them that they had brains of a fantastic high order, wordsmiths, craftsmen, and remarkable abilities, brilliant people in law as well. And a large part of our corpus after the independence movement, which the British called the mutiny, of IPC, CRPC, CPC, we all owe to Macaulay. And he culled out principles neatly. And subsequent to him came another man, Sir James Stephen, who did both the Evidence Act and the Contract Act, from which I've just read 232 and 56. So people who were very good at drafting and codifying and very precise, very categorical, very accurate, and very comprehensive. If you were to also ask me as to which is the case law to read, now there are hundreds and thousands of cases on this subject. High courts, there is 400 years of jurisprudence in England. There is 70 years of case law in India. And then there are Supreme Court cases. And it's amazing how with this plethora, if I was forced to choose for you as the interested listener or reader, I would say two judgments by two great judges. One of the past, Bangar's judgment in 1954 by B.K. Mukherjee. Incidentally, B.K. Mukherjee was the first Chief Justice of India who died in office. He resigned one day before and died the next day. He was also the person, by the way, whom Nehru asked to become Chief Justice after Patanjali Shastri finished his term. B.K. Mukherjee replied to Nehru. He said, Meherchand Mahajan is senior to me. I will not become Chief Justice if you overlook him. Nehru persisted, upon which B.K. Mukherjee replied that in case I am forced, I will have no option but to resign. Those were the times. This is an aside, but one of the most brilliant judges. He's the author of Bangar's case in 1954. I have lost you, but I'm seeing myself in a screen. I hope you can all see me and hear me. Can you all see and hear me?
Yes, sir. We can hear you and see.
The other judgment from 54, there are many, many thousands in between. The 2017 judgment of Energy Watchdog by another great present-day judge of the Supreme Court, Justice R.F. Nanak. And if you, by deeming fiction, are assumed to be more than interested, very diligent, very industrious audience, then you might want to read two more. Alopi Prasad in 1960 and Nehati in 1968. One, the first by J.C. Shah, a very aggressive person from Gujarat, but spent his entire life in Delhi. Very aggressive, very competent judge of the famous Shah Commission as well. The other one also, but by a very soft-spoken Gujarati, Shelat, Nehati, 1968. Now, to cull out principles from these 400 years of English jurisprudence and 70 years of Indian jurisprudence into a half an hour address on this subject is something like a fan dancer's job. A fan dancer's job, as you know, is to draw attention to the subject without really covering it. So, but let me nevertheless, at the risk of being oversimplistic, try and attempt that. The first principle, though this concept comes from the Latin phrase vis major. Vis major is a Latin, and force majeure is the French version of it. As you know, French is based largely on Latin. But force majeure is much wider than vis major. Vis major is a narrower concept of a physical event, a natural disaster, an earthquake, what they used to call in the old days an act of God. Force majeure need not involve physical events only, and is certainly not limited to it. It has been held in courts that it's a much wider concept and includes things like strikes, breakdown of machinery, etc. Second principle, English law only has persuasive value. We have our own two sections. We have to look at that. If we find lack of clarity in the section, we then have to look at Indian law. And the courts in India that English law is only as an additional persuasive value element. Don't think that you are cribbed and confined by the contours of English law. Third point is interesting. Where does this, what is the juristic basis of this principle? This principle of force majeure or frustration. Now, this is interesting because there could be three philosophies underlying it. And which is the correct one? nobody knows quite for sure, and I'll hazard a guess. One philosophy is that frustration occurs when an event occurs which is so basic to the contract, so obvious that parties did not write it in the contract, but so obvious that the parties said impliedly, if it happens, it's so obvious we need not state it in the contract. But if it happens, of course, obviously, it's all over between us. This is one philosophy, namely frustration is based on the presumed intention, presumed, because they don't say it, obviously, of the parties to the contract. The other theory could be that it is not what the parties presumably intended, because obviously they could never have intended such things. That's why they didn't say it. But when it happens, the court will apply the standard of a reasonable person. Parties did not say it, even impliedly did not perhaps think it. But when it happens, what would a reasonable person do? This is the reasonable man test. And English cases have, pointed out in different cases, different standards have been taken. The third is to apply a purely judge's standard. Parties be damned, contract never imagined or dreamt of it. I, the judge, will do justice by virtually rewriting the contract. That's the purely external, objective, judge-made approach. Which is correct? My fourth point of principle, no one knows. But obviously the first one is too subjective. Presumed intention may not be correct because the whole purpose of frustration is an event which nobody could have presumed or foreseen. So I would not go by it. The third one is too external. It's a judge rewriting the contract, which is not permissible. The judge's notions of justice cannot be allowed even when a supervening new event occurs. That would be too vague. It would be the chancellor's foot. It would depend and vary from judge to judge. There'd be no certainty. It would base itself on some unknown judge's power to alleviate hardship. That should not be allowed. So therefore, I would go by the second. Although the parties may not have thought of it, once it occurs, drawing from the context, the contract, the context of the bargain, what would a reasonable man do should be the basis. Now, the illustrations, of course, are useful because Macaulay and Stephens, with their precision drafting, each of these sections have illustrations. And I will not bore you with them. Section 32 has 3 illustrations. Section 56 has 5 illustrations. And by the way, in India, broadly the implied presumed intention theory is traced to section 32. And all other cases of frustration are put in 56. Although in England, the approach is that all frustration is mixed up. And both 32 and 56, there is no 32 and no 56 in England, there is no statute there, are treated commonly. So the illustrations have also been codified. For example, I agree in a contract to sing at a concert on certain days. On those days, the place where the concert is to be held is burned down on that day. The contract will be void because of supervening impossibility. Or I agree to sing or perform an act on days A and B, and on those days I genuinely and actually and factually fall ill. Well, that will again be a void contract. These are illustrations given in the statute and convey to you a starting point, very simple and elementary, but still important. And when you read the sections, you'll realize the precision with which the draftsman has worked. But continuing with the principles, and remember, I'm trying to summarize principles gleaned right from Old English law up to 2017 Energy Watchdog, the Adani case where I had the privilege to appear myself. Judges have emphasized that frustration and force majeure is not what you and I might think: difficulty, onerousness, toughness, even very inconvenient. They've used the word unless and until it upsets the very foundation of the bargain of the parties, we will not relieve the people. So it must upset the foundation on which the contract was made. Then they've said that it is actually a subspecies of the contractual doctrine of discharge. When frustration occurs, It is one out of many ways of how a contract is discharged. One way is frustration, there are other ways. A contract can also be discharged by performance. It can be discharged by frustration, etc. They have said then that it must destroy altogether the basis of the adventure and the underlying object for it to constitute force majeure or frustration. And mind you, I'm using the words interchangeably. There may be some technical differences which are not relevant for us. But it must destroy altogether the basis of the adventure and its underlying object. It is no frustration merely because it is the circumstances in which the contract were made, the underlying circumstances are altered. It is no frustration merely because parties necessarily assume at the beginning of a contract that prices may rise or fall, currency devaluations will occur. Frustration is not, these are all not my principles, I've culled them out from case law, from law. So this is the law of the land. Frustration is not a technique to absolve a party from difficulty. Frustration is not a vague plea of equity to do justice according to what a judge thinks is the justice of that case. And it is, the approach is that it must involve a situation whereby radically a new contract has emerged. Something which is not the old contract at all has emerged, which parties never contemplated to do. These are the principles. The object of telling you these principles is what? The object is that, and I hate to sound pessimistic, I hate to disappoint those of you who thought that I will come here saying, we have COVID and we can have frustration and force majeure right, left and center. It's a very, very difficult high burden, a very, very difficult threshold. It is not inconvenience and difficulty and hardship alone. Which now brings me to the third section, namely, how do these cases apply on the factual context? These hundreds of cases, but I chose 3 or 4 as examples, the most seminal ones. Actually, in fact, first one, Bangar, by B.K. Mukherjee in 1954. What happened to the facts? A person contracted with a developer to get developed land and building. And the developer was building a large complex by development, not merely an individual flat. While it was going on, this, remember, was in the context of the Second World War. While it was going on, under the Defence of India regulations by the British, a requisition order was passed. A requisition, unlike an acquisition, is a takeover of property for war or other emergent purposes, but for a temporary or a fixed period. It reverts back when that emergency or emergent situation ends. That's what happened in that case. It was taken over. The builder, I thought very reasonably at first sight, said, now it is taken over, I can't complete on time. And time is the essence of the contract. It is written in the contract. So I give you 2 options, Mr. Buyer. Take your money back, or if you insist, take the land on an as-is, where-is basis, subject to the requisition. The buyer sued, saying there is no frustration because the seller, the builder, the developer pleaded frustration, and he sued for specific performance. Now, interestingly, you might think, and I thought as well, that the seller was fairly reasonable, and the requisition was for a fairly long period, a few months. What did the court hold? The court held, no, there is no frustration of the contract. There is a temporary aberration. It can even be a temporary, the word temporary is crucial, suspension. But even if the war, and remember this is a war situation, even if the war was uncertain, it is not of such duration or permanence or semi-permanence so as to constitute frustration. That's factual example 1. Of course, Bangar laid down the law in the felicitous and great language of Justice Mukherjee, which stands to this day and has been reacted in 2017 by Justice Nariman. But I'm giving you the factual context, how you judge frustration. The second case I mentioned was the ghee case, Alopi. Alopi Prasad was a contractor who contracted during the Second World War for supplying ghee to the army. He went on supplying ghee, but when the war started and it became the peak, he was supplying before the war, then the war started. In the peak, he found two things. A, the price was too low, shortage was too much, and the price should have been much higher. He kept protesting, he told the army orally, but continued to supply, did not stop. And according to him, orally the army kept saying, you supply, we'll see later. When the war was ending or ended, he said, look, this was a force majeure in the sense that it had fundamentally altered the circumstances which I entered into the contract. Because of the war, I have to be paid much more. I can't even cover my costs. Again, remember, this is again a war example. All are of longer duration than COVID. And in a sense, during the pendency, perhaps even more serious than COVID. Social distancing doesn't help in war. Well, again, force majeure was rejected, not accepted. The third was Nehati's case, 1968, where a supplier of Pakistan sourced jute entered into a contract with another person. And the essence was that the supply could be made only if a license to supply is granted. Now, this was, of course, in the aftermath of the 1965 war, and we had special restrictions. But there was no absolute embargo on license. Licenses could be granted, but on a case-to-case basis. Ultimately, in that case, the license was rejected. So the man said, this is force majeure, I don't need to supply to you. License is a precondition. Court again held, again a third example of a war example, serious, and a rejection of the license, said no, license is on a case-to-case basis. There is no absolute embargo. And this was not understood by the parties to be a force majeure so as to excuse the supplier from his obligation to supply. I'm telling you Supreme Court cases, how they turn on the facts. Then at the end of that judgment is a very interesting passage saying even assuming that there was an embargo, they said there was no embargo, but they said even assuming there is an embargo, the contract is not frustrated merely because circumstances are fundamentally altered. It is not a situation where we will exercise power merely to absolve a party. And the context of the contract made it clear that you have to supply irrespective of all this. Look at the high threshold. All of I'm at pains to say all this to emphasize the very high burden of proof and threshold before you make out a case of force majeure, frustration, or excusing yourself from the obligations of a contract. Now the last, after which I come to the present day. The last is Energy Watchdog 2017 by Justice Nariman. And I appeared there for one of the losing parties. Tata's, Adani's, and a third company were there. I was for Adani's. All the private persons lost. And here is another case of commercial impossibility, unlike the, but not in a war situation. Alopi, the key case was also commercial impossibility, but a war situation. This is commercial impossibility. I thought a very strong case, but Justice Nariman rightly applied the high threshold of the cases I have just cited. The Adani's and the others had contracts to supply electricity. In the case of Adani's, they were sourcing it on Indonesian coal. And one of their main cases, which they ran in the Supreme, which I ran in the Supreme Court for them, was that Indonesian coal, by a change in law of Indonesia, doubled, trebled, or quadrupled in price, rendering it impossible to perform. And Indonesian coal being a fundamental substratum of the contract, Indonesian change in law being recognizable according to us, we should be excused because of frustration, force majeure. There's a clause there, clause 12, which had a force majeure clause. Justice Nariman negated it by a series of different reasons. And let me summarize them very quickly. One, he said there is no condition found anywhere in the contract that you had to source for generating electricity coal only from Indonesia. Your job was to supply electricity, not, it doesn't matter where you source the coal from. So it's not a condition, precedent, fundamental of the contract. Second, he cited an old 1962 House of Lords, well-known Greek ship case called the Sakir Glue, where, if you know, in 60s, there was the Suez conflict. And the ship owner and the carrier pleaded frustration, saying, I can't go through the Suez Canal because of the war. So the contract is frustrated. The House of Lords in that case, which Justice Nariman affirmed in Energy Watchdog, said, well, a great difficulty in doing something is not frustration or impossibility. You can jolly well go through down the Cape of Good Hope, down the south of South Africa, and there is no impossibility, and that was negated in that House of Lords judgment. So the existence of an alternative, mere price is the fourth principle. Mere price is not impossibility, is not force majeure, is not frustration. It must be a radical change in the contract itself. It should be a break with the old contract, so much so that the new altered supervening circumstances have created a new contract for the parties, which the parties never imagined. That's the test laid down by the Supreme Court. The fundamental basis of the bargain should not be enforceable. Here, Justice Nariman said, we could supply electricity. The contract remains for electricity. The fundamental basis is electricity, not how you procure coal. They also held, of course, separately, that what is recognized by Indian PPA, the electricity supply contract, is only Indian law, and a change in Indian law will give you additional compensatory tariff. But change in Indonesian law, Justice Nariman held in Energy Watchdog, does not constitute a change in law recognized in India. And therefore, for that separate reason, he also negated our case. I now go to your current situation, which you are most interested in, COVID, and some few paradigms, while taking a 1-minute detour that this is not the totality of frustration. There are some highly technical, very complex, pure corporate issues called MAEs, where frustration also comes in, which is known as a major adverse effect, or which arises in a context where company A and B have a merger, where B is the target company, A is the acquirer. And after the agreement to acquire, which is sometimes won in an auction, between the time of the agreement and the actual acquisition, events occur post the agreement, which completely and materially alter the condition of the target company. There, US courts have applied the doctrine of MAE, material adverse effect. And that's a very complex, not the frustration impossibility which we talk about, and I leave it because that's a subject matter of a seminar by itself. And there are very complex clauses, very long clauses and judgments, which I'm not touching upon. Let me now turn to the last part of what we are discussing today, without discussing wages. Or if Harsh wants, I can finish all of that, including wages, in about 5-10 minutes. I can ask questions on everything together. I don't know which way you want it.
I think, sir, if you can complete wages also.
Yes,
after
I'll take
your
10
this.
minutes, 7, 8, 10 minutes more and finish everything. Then you have enough time, not more than 10. Now, I understand that you are very keen to see the current context. Now, current context has various different situations. All this explanation prior to this was relevant because you had to understand what the law is. Now, the current situation has hundreds of practical everyday situations. A tenancy situation, where an agreement is for a restaurant, tenanted, or for an office, tenanted, or for a residence. Well, would FM apply on the principles I've just, in other words, if the tenant, for example, says, I'm entitled to waiver, at least for this period, I'm entitled to whatever. Now, remember one thing, everything depends on the clause. Suppose somebody has an actual clause, and I'm sure from now onwards you start putting very detailed frustration clauses in all your future contracts, including the word pandemic, which most contracts and most frustration clauses don't have today. So obviously there is a specific clause saying that in case there is a pandemic, or in case there is force majeure, and force majeure is defined as ABCD, then for those months tenancy rent will not be payable. Then that clause governs and not the law. But we are now talking of situations where people are not prophets, they are not astrologers, and very few people who contract put such clauses. So in that situation, my sad answer to hopeful ears is that force majeure on the principles I have just enumerated would not arise. You've seen in the examples I've given, a permanence is required or a semi-permanence is required. A commercial impossibility or difficulty or hardship is not enough. monetary issues are not enough. Fundamental alteration of the contract must occur. None of them happens. His job is to run a restaurant, but his tenancy is simply a tenancy. How he runs the restaurant is not the landlord's concern. In residential cases, it hardly arises because he will continue to occupy even during COVID. If he can't run his office, that's not the landlord's concern. Because in any case, above all, there is a huge temporariness about pandemic. Our worst case scenarios don't take the pandemic beyond May and June in this condition. And therefore, this period cannot simply be wished away as far as rent is concerned. Take a larger case, and you had this example in the press just today. It's a live example of today. ICICI Bank claims it has 5,300 branches on rent, 99% on rent, and spends about 1,200 crores annually as a rental for 5,300 branches. It has written to all to have waivers of rent. Now, remember again, I started by saying we're doing law here. In good faith, a lot of people will agree. We'll have novation of contract. We'll have new contracts. We'll have consensus. We'll have, grace and charm. But that's not what law is about. We are talking in case push comes to shove and you don't have agreement. Well, then the same sad fate on a contractual basis. So half of ICICI's landlords may agree, half may not. But as a matter of law, I doubt if ICICI can plead a frustration. A quick word about wages, and then a very interesting Hong Kong case on which I'll end. Wages has two levels, and this is important. Just yesterday, I heard that a PIL has been filed. PIL, not a government action, about a particular industry which is claimed will not pay, is not paying wages, which is wrong, but that's an example. Now, the principles here are, one is a contractual level as far as wages are concerned. I have a contract with my employee, that is you. You and I have a contract. So the terms of the contract will govern. I don't think any contract suggests that in case of a pandemic or a frustration of this kind, wages will be stopped. So contractually, you are clearly bound. And an individual employee or a group of employees with similar identical contracts can take you to court. I'm talking law. In actual fact, they don't. They agree with you. Deferment or payment later or payment with some increase later, these are all consensual things. But in law, again, there is no availability of frustration as far as the contractual level is concerned. Now we come to the legal statutory level. Is there something which overrides the contract of wages? Now you have seen there are a lot of letters, those of whom you are industrialists here, we're getting lots of letters from Ministry of Labour, from central government, from state governments, that here we are writing a letter, please ensure you be paying wages. Don't not pay wages. Don't stop paying wages. Now, I've already said that I would be aghast if employers stop paying without waiting for at least 2 or 3 months. As a public representative also, I think everybody needs a healing touch and we must do it. But I'm now talking as a lawyer. And I've already made the point as a lawyer that the contract would stand in favor of the employee. Question is, by these circulars or letters, does the government have the power to change this situation? The answer is no, because these are mere letters, advisories, recommendations, good faith, hope, expectation. They don't have the force of law at all. Now, a third level, there is one major exception to what I've just said. There is a Ministry of Home Affairs document dated 29 March 2020. This is the sole exception, which starts with the sentence under powers of section 10(2)(I) of the Disaster Management Act, 10(2)I. Now, this has the force of law because it is a notification under the Disaster Management Act. And this in the circular, says that you must pay wages. Now, what is the way out? You must pay, of course. And I don't think there is any doubt that this would constitute a binding directive. Why? Because it's not merely a letter or an advice or a recommendation. It is a statutory notification and it quotes the section. It's a different matter, and I'm not suggesting that you do it. I'm not suggesting it would win or lose or right. I'm not talking purely in the abstract as a lawyer. If a person, God forbid the COVID was to continue for 1 year, and one of you or 10 of you choose to challenge this notification next month, then you'll be able to challenge this notification and also the validity of section 10(2)(I) itself. Because if you read section 10(2)(I) of the Disaster Management Act, its language suggests nothing to do with wages and workers. It is about disaster management. Now, at one level, disaster management can include this. At another level, it can be limited by a judge to mean only that it is limited to physical acts and physical problems in disaster management. That will have to be tested in court, and that will have to be tested by a writ which challenges not only the circular, but the very validity of the section itself. That lies in the womb of the future. But let me give you a practical piece of advice. It is unlikely that any court in this situation is going to look favorably upon a petition challenging this directive of 29th March 2020 of the MHA. By the way, the Home Secretary is ex officio the chair of the National Disaster Authority, which is why it comes under the notification of the MHA. Therefore, while you are in law entitled to challenge, first and foremost, the chances of success appear bleak because judges, after all, lean in favor of sympathy, lean in favor of context, etc. But secondly, it is unlikely that you will have a result within the time within which COVID lasts. And COVID is likely to get over much earlier than the time your writ will take. That's a practical answer, but that's the legal answer. So in a nutshell, on the wages point, answer one, contractually, no FM. Legally, all documents minus one are advisories. Legally, one document 29(3)(20) is in fact a legal notification under a statute. Whether it is correctly, whether the statute is ultra vires, whether the notification is ultra vires the statute, are matters which can be tested in court. But the chances of success, especially during these trying times, is next to nil. Friends, I have come to the end, except that at the very, very end, I must cite to you a remarkable, very, very interesting case coming from Hong Kong. Actually, China, we should say. It's a Chinese case, but entirely English, because we forget that Hong Kong courts, as an exception to the Chinese mainland, administer English law. And this is a case which fits, the only case I have found, which fits today like a glove. And therefore, I must spend 3-4 minutes more before I end on it. It answers a lot of your questions, if this common law is correct. Because it's not Chinese law, it is English law, which is where we have got our entire 32 and 56 from, which is where our common law has come from. It was a case where in 2003, precisely on the SARS epidemic, directly based on the SARS epidemic, a landlord and tenant had a dispute. The tenant in Hong Kong said that the landlord in Hong Kong had given the tenant for a fixed minimum, what you call a lock-in period of 2 years, a premise. The SAR broke just after the tenancy. And for about a month, thereafter things came back to normalcy about movement. This man could not live there. Obviously, because it was affected. In fact, in Block E, where he was tenanted, in that very block, some people had been found to have SARS, S-A-R-S, in 2003 and had been isolated. So he legitimately moved to some other place. When he came back, he said, I am giving up the tenancy. What advance I have given you can keep, but I am not keeping it for a minimum of 2 years. The landlord sued for specific performance. The tenant pleaded frustration. That's how the case arose. In a very well-written judgment, the judge has summarized the English law by reference to 2 or 3 cases which are bang on point and apply directly during COVID times. The judge referred to a Panalpina case of 1981 by the House of Lords. And in the Panalpina case, the House of Lords held in a case where a lease was given for 10 years of a warehouse. But the city council closed the street, which was the sole access to the warehouse. And that opened much, much later, almost a year or 2 years later. The person who wanted to wriggle out of the contract pleaded frustration. Remarkably, the court held no frustration. They said the closure was expected to last a year, year and a half, which would still allow the lease to run for 3 further years. So again, duration, permanence, temporariness. Look at I'm giving you much worse cases, not a few months cases, which what COVID is. Another judgment, again of the House of Lords, called Cricklewood property, which is of 1945. This Panalpina is 1981. Panalpina relied on Cricklewood of 1945, where again frustration was negative in a 99-year building lease, where the tenant claimed that wartime restrictions, building restrictions in a 99-year lease, had frustrated the lease. The House of Lords again held that it's a long lease, you have enough time, the duration of the frustrating event was not sufficient to constitute force majeure. Now, that is where I want to end, but I think it is worth it to spend a couple of minutes more to read to you how high, in what words the Panalpina judges formulated their approach. And I just want to take the liberty of reading to you a quotation from this judgment. From Panalpina, Lord Simon said this: frustration of a contract takes place when there supervenes an event without default of either party and for which neither party has made provision, which so significantly changes the nature, not merely the expense or onerousness of the outstanding contractual rights and obligations from what the parties could reasonably have contemplated at the time of its execution, that it would be unjust to hold them to the literal sense of its stipulations in the new circumstances. It is in such cases and such cases alone that the party declares that they are discharged. So, not merely the expense or onerousness, when it so fundamentally and significantly changes the nature of the contractual obligations. Then he goes on to say, the initial judgment, when a contract is interrupted by a supervening event, the initial judgment is quantitative. What relation does the likely period of interruption bear to the outstanding period of performance? But ultimately, this quantitative test must be translated into a qualitative test. Namely, in the light of the quantitative computation and of all other relevant factors, would outstanding performance in accordance with the contract differ so significantly from what the parties reasonably contemplated with those literal terms? It's virtually, to oversimplify and crudely put it, saying whether a swan contract has become a crow contract. Only then frustration steps in, not merely because prices, commercial impossibility, inconvenience, monetary, etc., etc. In fact, in the Cricklewood case, in Chitty's case of contract, very interestingly, there is a sentence that says, I am struck by the fact that there appears to be no reported English case where a lease has ever been held to have been frustrated. This is a country which went through 2 world wars. Not a single case where frustration has been found in a lease case. And accordingly, the Hong Kong judge, applying these principles, held in favor of the landlord against the tenant and held no frustration. Friends, I have come to the end. All I want to say is that both in wages and in the general concept of frustration, the chances of being able to legally get out of obligations within the 1 month or the further 2 months we may suffer is, I'm talking purely legally, unlikely, possibly impossible. However, judges decide as individuals. I'm only here to give you legal principles. It is not that every judge follows legal principles. It is not that every judge doesn't have a crying heart. Individual cases may wrongly succeed. Individual cases may wrongly fail. So that's an individual situation. But this is the law, and I'm very clear on the standing law, the law as it stands today. No case of frustration is made out in the widest sense, in all the senses which we understand, as far as COVID is concerned, or indeed as far as wages are concerned. Thank you.
Sir, thanks a lot, sir, for your deep observations. Now I'll request everyone to have maximum participation. If we will take few questions, and I'll request not to have observation or suggestions. If you can directly ask your question, and if you can keep it short, so that maximum can take benefit of this opportunity. Akash, can you take questions? Those who have raised hand, we can take questions from there.
I'll be choosing questions at random. I don't know what the questions are. I just
Right. That's
announce
fine.
the name and the name can ask the question. The first question we have is, I see a raise hand from Ashish Dhadiwal. Please go ahead and ask your question.
Sir, good evening, sir. Ashish Dhariwal, Chief Secretary, Vizag Chapter. Can you hear me, sir?
Yeah, we can hear you. Please ask
Yes,
your question, sir.
Okay, so my question is very simple. One of my properties I have rented out to a medical diagnostic center which is running. But however, they send me a notice that they have cited the force majeure clause saying that we cannot pay you rent, in spite of the fact that they are running the entire clinic and the testing facility. What are your views on that, sir?
See, first of all, it's very dangerous to expect that here are some kind of a remedy or advice. This is a oral talking, so please don't rely on this advice. Otherwise, you might end up suing somebody for negligence. Number one. Two, you are, from all the principles you heard, the answer should be clear to you. The answer should be that you're a happy landlord who stands in the winning position. It's as simple as that. Number three, in fact, yours is a stronger than average case because they appear to be running in some form or the other. I have given answers even in cases where people can't temporarily use their premises.
I'll request participants
Thank you,
to not to be ask a specific, in general, in principle, you can ask the question rather than your individual case, because this forum is for academic and knowledge sharing. So you can understand the principle and accordingly you can interpret in your case. So my request, in principle, ask question, whatever your query or doubt is there. Akash, please go ahead.
Thank you. Randomly selecting the next person is Shrenik Mehta. Please ask your question. Hello, Shrenik.
No, I haven't raised my hand.
Okay.
I do not have a question. Thank you.
Next is Pramod Jain.
So Pramod Jain, you please go ahead with your question, Mr. Pramod Jain.
Yeah, good evening, Dr. Singhvi. Can you hear me?
Please go ahead with
Yes.
please go ahead.
Yeah, okay. I just wanted to know that how exactly you handle a situation where you are applicant as well as defendant in such situation. Suppose new case coming, and second, what exactly happens to the ongoing recovery proceedings in civil matter?
I don't understand your question. I'm sorry. You have to be more specific. First question.
No, I'm just saying. No, let's say I'm running an NBFC and wherein I have lent money and I receive money as well. Right. If I'm not getting the backward money, I can't give the forward money. How exactly I handle the situation?
There is a very well-known English saying, what is sauce for the goose is sauce for the gander. So the principle of law doesn't change depending on whether you are a borrower or a lender. Principle of law remains the same for everyone. Number one. Number two, in all the examples I've given, the weakest example of frustration is commercial difficulty. That appears to be the substance of what I've said as far as the existing case law is concerned. The only 2 or 3 ways in which you can be saved are A, if somebody has had the remarkable prophetic astrological foresight to put a clause in the contract, which very few people would have thought of in terms of an epidemic or a pandemic. Then obviously the contract will govern. In a hypothetical contract between you and me, if we have agreed that this kind of an epidemic is an excusing circumstance, then yes. But absent such a clause, which is 99% of the cases, which is why the doctrine of frustration, the answer is that mere difficulty cannot be an excuse for non-performance. Whether you are, for that negative answer, a buyer or a seller, a lender or a borrower, it doesn't matter. What's your second question?
How exactly one handles the ongoing with the civil proceedings for the recovery, which are already ongoing in the court? What exactly happens?
It doesn't affect. The only thing that happens, it gets delayed because some courts are not functioning. You may be delayed slightly. You may have to wait, but the proceedings which were pending prior to COVID lockdown or otherwise are absolutely unaffected. There are only the effect is sometimes, a lot of procedural things are relaxed. For example, suppose your limitation, if I had to sue you and my 3-year limitation to sue you expired in the middle of this period, that gets automatically extended. If I had to do some compliance on a particular date, say I had to serve you by so-and-so date, then I'm not held in default by not serving you. Those procedural things are relaxed, but substantively there is no relaxation on the ground of force majeure, etc.
Thank you, sir. The next question we have is Dr. Mamta Jain, and then after that, Ashok Ajmera ji. Dr. Mamta ji, ma'am.
Ms. Mamta Jain, please go ahead. We can hear you.
Yeah. Yeah, hi. This is Dr. Mamta Jain, Medical Superintendent of Maharaja Agrawal Hospital, Delhi. I have one query. Hospital comes under the essential services. And as per the Disaster Act also, all the people are supposed to serve. Whenever they have a duty, they are supposed to come. Now, the problem which I am facing is, as per law, and Mr. Singhvi also explained, we are supposed to make the payment / salary to all the staff, right? But when they are not turning up for their duties to serve the patient, in that case, what I am supposed to do? Shall I take the action as disciplinary action and deduct their salary because purposely they are not turning up? That is my problem.
You are a special case. You don't apply in the normal wages category. In your case, because both you as the employer and the people who are not coming as the employees are in a position to work, not only in a position to work, under an obligation to work. So you are an exception. You are the normal rule when normalcy prevails. So to you, the normal rule will apply. What is the normal rule? The normal rule is that if a person absents himself unreasonably, he can suffer all the consequences, A, of disciplinary action, show cause notice, suspension, etc., leave without pay, and even dismissal. That's number one answer. Number two, in particular in your case, it is doubly so because you would probably have notifications for the medical staff that they are completely, and even for the non-medical staff, the clerical staff, there will be some degree of essentiality. So certainly, if you find that if I'm actually not able to come because of illness or something, or I'm in isolation, then obviously you cannot do what you're saying. But normally, if you find that I'm faking it, which is what you are suggesting, if you find that I'm faking it, then obviously you are entitled to take all disciplinary action, including cutting off pay, because you are an exception by law.
I gave them relaxation that you can do the duty of 1 day, 10, 12 hours, and take off for 1 day, 2 days. But still they were not, they are not turning up for 20 days, 10 days. How much you can give the relaxation to your staff, because you have to run the hospital as well as you have to take care of the patient whosoever is coming.
I take that as an observation and as a lament, to which I have no answer, but you are right.
Yeah. So that's why I thought that let me take the legal opinion. Thank you. Thank you.
Thanks a lot, ma'am. We'll move on to the next one. Mr. Ashok Ajmera, please
go ahead. Yes, sir. I am Ashok Ajmera. I have a question on, in Negotiable Instrument Act, Section 138, check bouncing and other thing. The checks were actually presented in the banks because the due date was there. Checks have not come back from the bank because of the courier services. The notices cannot be sent to the people because of the stoppage of the couriers and postal services. So whether the time limit will accordingly be extended, or this check deposit will go waste, or what are the consequences of this? And I have another question also after this. One more question. Yeah.
I was part, along with the Solicitor General, in the court proceeding when the Supreme Court passed a very clear and general order that all such limitation time periods shall be proportionately extended. So you are safe there, whether as an accused or as a complainant. This is not one example. There are hundreds of examples. Of course, if somebody tries to be over clever and use it as an excuse when there is, the time is different, or, he's actually out of limitation before COVID or before lockdown, and he tries to, pretend that it's because all those are special factual cases. But as a general rule, the rule which the Supreme Court order is passed, you can get a copy of that order from the website of the Supreme Court. Wherever there are periods of limitation prescribed, from surveys to appearance to notices, to filing, to appeals. Everything has a particular limitation, 30 days, 90 days, 60 days. All of them are proportionately extended to a few days after the COVID lockdown opens. That's a very clear order of the Supreme Court. And any court to which you go will allow that.
Thank you, sir. My second question is on the
Just Ajmera ji, 1
force
second.
majeure clause itself. That everything is basically related with the commercial benefits, commercial frustration. I mean, ultimately, at the end of the day, the force majeure is related to your non-performance of certain contract, which will amount to be a commercial loss or commercial handicap. So when you say that if a commercial handicap is there, then this clause may not be necessarily applicable, then what for this clause is, I mean, these words are actually defined, and what for it has been put into the legal terminology.
See, when you go into something, you then realize how surprised you are. There are large areas of knowledge out there where your popular perception does not match the actual law. It has always been a popular perception that frustration means difficulty, hardship, commercial difficulty, price rises, impossibility in a commercial sense. Actually, for hundreds of years, the law of frustration has been not that at all. Now, that doesn't mean that there are 100 other ways in which the judge can give you relief. Judges have other ways of giving you relief. But in the law of frustration, which is why I took the first 20 minutes of my lecture to trace it from 400 years of English and 70 years of Indian law. I gave you examples of war. Frustration doesn't mean what you and I popularly, in anecdotal terms, thinks. That is true of so many areas. We have misconceptions about so many areas, not only of law. And the purpose of this webinar, one of the purposes is to remove those misconceptions. It's as simple as that. It must mean that you and I agreed to do something which by changed circumstances, we have virtually made a new contract which none of us imagined. That is not commercial difficulty. It is, that's why those words I read to you. Radical break, break in link, fundamental substratum, commercial and price in particular. Energy watchdog is a good example. Justice Narendra has cited 3 cases, not one. I gave you only one, the Greek case of the ship Sarkri Glue, which said you go down the Cape of Good Hope. Now, can you imagine your ship lost through Suez versus Cape of Good Hope? The entire commercial thing goes for a sixer. Similarly, there are 2 other cases, Tennants and Peter Dixon, where they said that we are giving you relief. If it was only price, we will not give you relief. If it is only commercial impossibility, we will not give you relief. We are giving you relief because the entire contract has changed from a swan to a crow. Now that's the law. It's no point. You can question it only by legislative amendment.
Thank you, sir. The next question we have is from Pratik Jain.
Hello, sir. Good evening. So my question is, one contract is for a specific date and for a specific function like marriage, and it can't be happen because of pandemic. Will that force majeure clause be applicable?
I did not hear the last part of the question.
So suppose a contract is for a specific date for a specific function, say for an example, a marriage, and that could not be happened due to pandemic situation. Would that force majeure clause would be applicable? And if it is applicable, then what would be the next recourse? Whether we can file it for unjust enrichment, and would the amount paid is for advance would be recoverable?
Thanks
You
for
are
the
right.
question.
You are wrong by giving the example of marriage. Marriage is not a contract in Hindu law or Indian law. So that example doesn't work. There's no question of there being a contract of marriage which is void. However, you are
for
right.
event manager, not as a.
You are right to the extent you are talking of the other thing. The classic example given in the old case of 200 years ago, Taylor versus Caldwell, is when I agreed with you to perform. And my performance, for which thousands of rupees were spent and hundreds of millions of people were ready, got washed out because the auditorium got burnt one day before. Now, does my contract become void? This is the same example which you are giving. The answer is yes. And once it becomes void, it means that people are left to the original status. You have to refund your things and just get on with your life.
Mr. Puneet Chaudhary, please go ahead. Mr. Puneet Chaudhary. You have raised hands.
Yeah, Jai Jinendra, good evening. My question is more from a BFSI industry standpoint. From our standpoint, there are contracts which are borrowing contracts under regular loans, as well as in foreign currency, could be non-fund based letter of credits also. So many of those contracts have expired or have come up for maturities, but could not be honored in this pandemic. So what happens to them? Because most of the lending institutions are trying to enforce this against the people who have availed letters of credits or foreign currency derivatives, or maybe simple loans. That's one part. The other part is
Just finish.
what all corporates can invoke the act of God and take an insurance cover for their manufacturing facilities or their corporates? These are the two questions. Thank you.
First question, if I understand you, is that they could not be enforced means what? I'm not able to understand you what it means. Could not be enforced.
So the lenders have started sending notices to all these borrowers who could not either honor their LC commitments or foreign currency derivative maturity. While forex, the foreign currency has moved, rupee has depreciated 7%, which has led to a lot of knockoff of the.
The answer in law, there are two answers. There is one answer is in practical fact, the other is in law. In law, the contract remains and the obligation of the payer remains. There is no frustration. It only postpones it. Maybe he has to do it 1 month, 2 months later. Question may arise whether you will charge him interest. There may be an RBI guideline you can't. There may be some dispute and you will agree, okay, give me the main amount, but not the interest. But those are matters of negotiation. I'm talking of law. In law, the answer to your query is that COVID does not cancel the contract or absolve the person of his obligations. Very clear.
Now I think since time is
unless you have a specific clause in the contract.
Hemant Sadi has question. Hemant Sadi.
Yeah. So we will take 2 more questions, 2 or 3 more questions, and then we need to conclude by 6:30 or so. Please, Hemant Shahji.
Sir, in case of a maintenance contract, can we apply force majeure? So we can say that he cannot provide service, or can a person who is receiving the maintenance contract, can he ask for extension that for the period is shutdown, he can get extension?
That's an interesting question. Extension he cannot ask as of right, because that's the rewriting of the contract. And possibly to the limited extent that for 2 months, physically you cannot come and repair my AC or fix my fridge. Just is a matter of fact, which leaves parties where they are. Nobody's going, unless the person decides to sue you for those 2 months, to which it would be a valid defense. So I would say that frustration for the limited period of the actual inability to move would be accepted. But A, the contract would not be cancelled. B, the contract would continue immediately after pandemic ends. C, there cannot be as of right an extension pari passu or proportionately of the period. To that extent, frustration succeeds for 2 months or whatever the period is.
Thank you, sir.
Mr. Sushil Solanki. Mr. Sushil Solanki, you have his hand. Akash, can you please unmute Mr. Sushil Solanki?
Yes, sir. Please go ahead.
Mr. Solanki, are you there? Please go ahead.
No question. I don't have any question.
Okay, there was hand raised. Okay, Mr. Abhishek Mahawar, are you there? Akash, if you can unmute Mr. Abhishek Mahawar. Yes, sir. Please go ahead.
Yeah, good evening, respected Singhvi staff. Abhishek, I just wanted to understand whether Disaster Management Act, since it has been invoked by the Union, the Ministry of Home Affairs, can this natural calamity be also be classified? I mean, this pandemic, can it be classified as natural calamity? Because the natural calamity term as a term has a lot of significance under RBI. Just wanted to understand, a lot of human cry on one-time restructuring not being allowed. But the moment the central government or state government terms it as a natural calamity, automatically the restructuring route is available for the borrowers. Now, I wanted to understand, Disaster Management Act has been invoked, and disaster as a definition in the Act itself defines this biological, issue as a disaster. So, can we indirectly say that natural calamity and pandemic, this pandemic is natural calamity?
You see, your question is twofold actually. It is factual, contextual on the one hand, and legal on the other. That, in common understanding and even under the Act, this natural calamity is undeniable.
Okay.
It certainly is. But that is not the same thing as saying that the government, the consequences which you are looking for it to be a national calamity, there are consequences which flow from it. Those consequences will not flow unless and until the central government chooses to notify it. A notification will have to be issued. Now, the central government knows as well as you do that the moment they notify it, they will be obliged to spend monies about A, B, C, D, including, if I recollect, certain states can ask special concessions also.
Correct.
So the central government is unlikely to notify it. There is no provision in the Disaster Management Act which says that absent a notification as a national calamity, the consequences of RBI or others you are looking at will flow. So unless and until the government chooses to generally notify it, which I'm sure they will not, they are doing it individually. The RBI is saying this category of loans can be excused or deferred or delayed. The RBI is saying this category of transactions can be favored. But a general notification of national calamity will have to come. Absent the notification, the legal consequences therefrom will not flow. And we have no such notification, although in actual fact and context, it is a national calamity. In fact, it's an international calamity.
Correct.
Including a national
Mr.
calamity.
Darpanjan, Mr. Darpanjan, you had raised hand. Mr. Darpanjan.
Yeah, as a last question, Mr. Darpanjan.
Yes.
Yeah, good evening, sir. My question is this, the lockdown period, what the government has said, it is going to, the act which is there on 29th March, it is going to be there till 3rd of May, or it ends in the month of March?
Which act?
The payment which we need to pay to the employee.
No, you see, as far as the government is concerned, in the 29th of March notification, it has made a general declaration supposedly under section 10(2)(I). Nobody knows whether that section applies or not. That will be decided in the court of law ultimately. That nobody shall stop paying wages. So it is not a time-bound direction. It is saying what was happening earlier will continue to happen. So it was happening earlier, it will continue to happen in the future.
Okay. Thank you, sir.